Welcome to This Explainer. We're getting straight into one of the most powerful tools in Admiralty law, vessel arrest. It is exactly what it sounds like, the legal detention of a highly mobile ship to secure a maritime claim, basically stopping it in its tracks before it can just sail away and leave you empty-handed. Here is our roadmap for today. We're covering 1, purpose and grounds, 2, sister ship arrest, 3, the procedure, 4, release and wrongful arrest, 5, a real-world application, and 6, the foundational case. We're going to move patiently from the basic concepts all the way through to the specific legal steps in case law. Let's jump in. Part 1. Purpose and grounds. So let's figure out exactly why the law actually lets someone hold a massive ship hostage and what grounds you need to do it. To grasp this, let's put it in plain English first. We're freezing a physical asset to ensure we get paid, and we're using that frozen ship to force a court to hear our case. Now, the precise legal terms for these two goals are security and founding jurisdiction. For security, which is the primary purpose, you don't even need to fully prove your case on day one. You just need to show a good, arguable case. And for founding jurisdiction, historically, the very act of grabbing the ship is literally what gave the court authority over the dispute. It's a foundational concept that still drives everything we do in admiralty practice today. But, you can't just arrest a ship on a whim. Under Section 5 of India's 2017 Admiralty Act, you have to meet highly specific statutory grounds. Broadly, this means the person liable owned the ship when the claim happened and still owns it now, or they were the demised charterer. It also covers mortgage claims, active ownership disputes, or maritime liens. Think of it like this. If two companies are locked in a bitter fight over who truly owns a vessel, one of them can use this rule to freeze the ship so the other guy can't just sell it off during the lawsuit. But the rule is strict. If your claim doesn't fit perfectly into a Section 5 category, the court is going to say no. Part 2, sister ship arrest. Okay, so what happens when the ship that actually caused your problem is long gone or just sitting safely out of reach? Well, you can arrest a sister ship. This is a huge deal because it gives the arrest powers some real teeth. If you can't get your hands on the offending vessel, that's the actual ship involved in the claim, you can legally detain a different ship owned by the exact same person. But pay attention to this rule. It requires absolute, undeniable common ownership. It is not enough that the two ships are just vaguely associated within the same corporate group. Now, ship owners know this rule well. They deliberately structure their businesses by putting each vessel into its own single ship special purpose vehicle, or SPV. It's a legal shield. If ship A causes a massive oil spill, the owners want to make absolutely sure you can't just go and arrest ship B to pay for it. Because of this maneuver, trying to pierce that corporate structure to prove true common ownership is one of the most heavily litigated battlegrounds in admiralty law right now. Part 3. The procedure. All right, we know the grounds. Let's walk through the actual step-by-step mechanics of executing an arrest in India. There are 5 critical steps here. First, you file an admiralty suit in a coastal high court, places like Bombay or Gujarat. Second, you apply for an arrest warrant. And here's the kicker. You do this entirely in secret. Because if you tip off the owner, the ship will just sail away, right? The precise legal term for this secret, one-sided application is ex parte. Step 4, the court issues the warrant and an officer physically detains the vessel. Step 5 is holding it until the claim is resolved. But hold on, we skipped step 3, which is incredibly important. Because you're asking a judge to freeze a massive asset ex parte without hearing the other side's story at all, the court demands a safeguard. The claimant has to furnish an undertaking as to damages. This is a formal, legally binding promise that you will compensate the ship owner if it turns out your arrest was unjustified. It is the ultimate reality check against abusing this ex parte power. Part 4. Release and wrongful arrest. A detained ship bleeds money by the hour, so let's look at how an owner actually gets their ship back once it's caught. In plain English, the owner gets a guarantee from their insurance provider. The precise legal term for this is a letter of undertaking, or LOU, issued by the ship's P&I club. This is a formal, written promise to pay up to a stated amount if the claimant wins the lawsuit. In the international shipping world, this LOU is universally accepted as being as good as cash. It's a lifesaver for the owner because it means they don't have to drain their actual cash reserves or get a bank guarantee just to free the ship. But what if the arrest was totally baseless? Say the claim wasn't even a valid maritime claim under Section 5, or the claimant flat out lied to the judge. In that case, the ship owner can turn around and sue for wrongful arrest. It's a severe penalty, and it's exactly why that undertaking as to damages is required up front. Courts do not take ex parte applications lightly, and they will scrutinize them heavily to prevent exactly this kind of abuse. Part 5. Real-world application. Let's make this concrete and see how the intense commercial pressure actually plays out in the real world. Picture this scenario. A bunker supplier hasn't been paid for fuel. They file a suit and arrest a vessel sitting at the port of Mumbai. The absolute second that ship is detained, the owner starts hemorrhaging money. We're talking off-hire penalties, demurrage exposure, severe reputational damage. It is a logistical nightmare. Because every single hour is so devastatingly expensive, the owner's P&I club is going to scramble to issue an LOU immediately just to get that ship moving again. This scenario shows you exactly why an arrest is such a ruthless commercial pressure tool. But to reaffirm our rule here, it's precisely because the pressure is so intense that the law insists on that undertaking as to damages. It is the essential barrier keeping claimants from using the court system to effectively extort ship owners. Part 6. The foundational case. Let's wrap up our legal analysis with a 1993 Supreme Court judgment you absolutely have to know cold. MVE Elizabeth v. Harwin Investment. We're going to treat this case with the rigor it deserves. The facts were pretty straightforward. A foreign-owned vessel damaged a cargo of fertilizer that was en route to Indian ports. But the legal issue it raised was monumental. Back in 1993, India's Admiralty statutes were basically a patchwork of old, fragmentary colonial-era laws. So the big threshold question for the Supreme Court was, did Indian high courts even have the jurisdictional authority to hear this case and order an arrest? The Supreme Court's holding was a total game changer. They ruled that no, admiralty jurisdiction is not just frozen in 19th century English statutes. They held that every high court with original civil jurisdiction possesses inherent admiralty jurisdiction. This means they draw on international maritime law, justice, equity, and good conscience, regardless of whether there's a specific local law written down covering the exact point. The profound impact of this holding cannot be overstated. The MV Elizabeth ruling effectively built modern Indian admiralty law straight from the bench. It empowered courts to act literally decades before Parliament finally caught up and codified all these rules into the 2017 Act. All right, structured recap time. Let's lock this in with a quick review of every core concept, doctrine, and case we've covered today. Tracing our exact teaching order, we started with detaining the ship, learning the dual purposes of security and founding jurisdiction. We then mapped the statutory basis to Section 5, ensuring claims match specific grounds like ownership disputes or maritime liens. We looked at expanded leverage with the sister ship rule, where you absolutely must prove common ownership to pierce those single ship SPVs. Then we covered the release mechanism, moving from cash to the globally accepted letter of undertaking, or LOU, from a P&I club. And we anchored all of it with our key precedent, MV Elizabeth, which firmly established inherent admiralty jurisdiction. I'm going to leave you with this final thought for our explainer. When you consider the sheer unilateral power of an ex-parte arrest, the ability to paralyze millions of dollars of global assets quite literally overnight, how do our legal systems truly balance the swift pursuit of commercial justice against the catastrophic risk of corporate ruin? Something to think about. Thanks for learning with me today.